for presumptively lawful.
Mike Rapp.
So this is a follow-up on Mike McConnell's question of you, Mike Paulson. So you said, so you divided up the world into clear cases and then sort of, I guess, unclear cases. And so the way I divide it up is there's sort of clear cases, there's close cases, and then there may be tie cases. And in the close cases, we go with the stronger evidence. Close, reasonable minds may differ, but you know, my judgment is we go with the so your response to Michael McConnell was, oh, well, we don't do that because there needs to be a contradiction between the Constitution and the statute. But that begs the question of what the meaning of the Constitution is, and we might determine the meaning of the Constitution is determined by the best evidence rather than the clear evidence.
Yeah, that's a great question, great insight. I said there will be, that you need a hermeneutic rule for what you do with a sufficiently determinate text, and then there are different rules for what do you do when textual meaning runs out, right? You could put a category in between. I mean, what is your methodology for determining when an issue is sufficiently determinate or sufficiently or not sufficiently determinate that you can say that the Constitution applies a rule? If I hear you right, basically you're saying that there are going to be some hard cases in terms of where that line is as to when an answer is sufficiently clear that a court can apply it as law. But I think that's an unexceptionable point. It's not probably a point of disagreement. Originalism is a methodology and a default rule that if there is no answer, you go with you can't invalidate what was done. We'll have some hard cases as to what falls within that interpretive principle too.
I think your question also points to the fact that there's going to be, that you can have different kinds of standards of deference that you might want to adopt, and that's really, I think, separate from a theory of originalism. You need a theory of constitutional adjudication to tell you how deferential should you be when the evidence is uncertain. So when you say, as a judge, I would say, well, this seems most reasonable to me, my inclination is to think you need a higher standard than it seems reasonable to the judge before you overturn the decisions of a legislature. But you need a theory, and it's not originalist theory, it's a different theory, to tell you where that bar should be set.
Unless you think the 5149 view was an original method, and that's how people would have understood it, in which case it is part, I would argue, part of originalism.
Yeah, but you do.
Stephen? This is just a follow-up to that question in some sense. For Michael and Keith, if it were determined that the founders were intentionalists and whatever kind of